EDD is auditing your business. You might feel trapped, like there's no way out except for paying them whatever they say you owe. But here's the truth. The state of California doesn't advertise. You can settle with the EDD auditor. You can cut penalties, narrow the audit, and in some cases even erase entire years of exposure. The key is knowing when, where, and how to negotiate, because timing is everything. Stick with me for the next few minutes and I'll show you the 4 stages of an EDD audit, where settlements actually happen, and how to use each one to protect your business. The EDD doesn't like to use the word settle. You'll see terms like adjustment, abatement, or administrative resolution. But make no mistake, that's exactly what a settlement is. It means you and the EDD agree on how to close the audit. Maybe by dropping older quarters, reclassifying only certain workers, or reducing penalties. And here's the big secret. The earlier you bring up settlement discussions, or more likely your representative, the more leverage you have. Why? Because auditors are under the same pressures you are. Deadlines, quotas, statute expirations. That's why the first phase of the audit, the entrance interview, is your best opportunity to shape the entire outcome of the audit. EDD audits happen in 4 phases, and each one opens a new settlement window. The entrance interview. This is an opportunity for early damage control. This is where we start limiting the scope of the audit. We show up with a worker classification matrix. It lists every payee, their role, and how they meet AB5's ABC test. If we can show early that certain freelancers or consultants are clearly independent, we push to exclude them before sampling begins. This saves you months of pain and possibly tens and thousands of dollars in employment taxes. The pre-assessment phase. A supervisor conference when the auditor finishes their draft finding. That's your next chance. We meet with the supervisor and negotiate adjustments before notice of assessment is issued. Supervisors want clean closures, not appeals, which means they often have flexibility to drop penalties and narrow classifications. Appeal to the CUIAB. If the EDD still issues an assessment, you could file a petition for reassessment within 30 days. This pauses collections and moves your case to the tax branch legal office. This is where attorneys, not auditors, take over. This is where the real settlement leverage begins. The settlement office, last stop before trial. Even after an appeal, the EDD has a settlement program modeled after the FTB and CDTFA. We've seen clients' liabilities cut in half through this process, especially where the case involves legal gray areas or hardship factors. How to limit the damage. When we enter an EDD audit early, we aim for what we call a scope settlement. That means we negotiate which year and which workers get reviewed. We use 3 main tools. The 3-year rule. Unless the EDD can prove fraud or unfiled returns, older quarters are off limits. We use that to close out years before they even start looking. Documentation swaps. We provide complete index worker files in exchange for auditors skipping site visits or worker interviews. This prevents unnecessary exposure. Narrative control. By controlling the evidence and explanations, we prevent the EDD from taking small inconsistencies and turning them into badges of fraud. The result, a shorter, cleaner audit and far fewer surprises down the road. The supervisor conference. This is a hidden opportunity. Most business owners are exhausted by this stage of the audit, but this is where the real magic often happens. Supervisors have the power to drop late filing or misclassification penalties. They can reduce the number of workers or quarters reviewed. They can allow statistical sampling instead of full tracing. We bring a penalty abatement brief citing hardship, natural disaster, operational disruptions, backed by real evidence. In many cases, the supervisors sign off on a reduced penalty regime right there in the meeting. Post-assessment settlements. When the case goes legal. If the EDD won't budge and issues an assessment, don't panic. Once your case hits the CUIAB, everything changes. Now you're dealing with attorneys who must weigh litigation risks, not auditors who only care about checklists. That's where our team leverages pre-hearing briefs, witness prep, and procedural defenses to expose weaknesses in the EDD's case. When they see strong legal footing and organized evidence, they often agree to reopen settlement discussions. Some of the best outcomes happen right before the hearing, with penalties and liabilities cut dramatically. No matter what stage you're in, these 5 levers can shift the balance in your favor. Statute pressure. Remind the EDD that key quarters are about to expire. Worker hardship. Show that reclassification harms legitimate contractors. Prospective compliance. Offer to reclassify going forward. It creates goodwill and future payroll tax revenue to the state of California. Payment plan readiness. Bring a structured payment plan. The EDD prefers certainty over appeals. Cross-agency risk. Explain that crushing your business means less tax collected long-term. That logic often wins concessions. Why privilege and dual licensing matters. Your CPA or EA can't negotiate legal settlements. They're not trained for it. They can't invoke privilege. And anything you say to them can be subpoenaed. At our firm, every CPA who works under attorney-client privilege because we're a law firm. This means your communications, your records, and defenses and strategy stay confidential. Even a criminal referral scenario. Our dual licensed team of attorneys and CPAs speak both languages, the law and accounting, which lets us dismantle weak audits and close strong settlements. If the EDD has contacted you or requested payroll records, you're already in the danger zone. Don't face them alone. Call the tax law offices of David W. Klasing at 800-681-1295 or visit klasingassociates.com to arrange a reduced rate initial consultation. We will help you limit exposure, protect your rights, and turn a potentially devastating audit into a manageable settlement. When it comes to EDD, it's not about avoiding the audit, it's about surviving it strategically.